Hello, and welcome back to Coin Lady channel. Please reverse your ruling in the SEC versus Ripple lawsuit, Judge Torres. Is there any chance that the section of the ruling that said XRP wasn't a security would be overturned by a higher court? Also, how about Allure? When may we expect an appeal from either the SEC or the other side? Is there any chance of a settlement now that Judge Torres has ruled on the bulk of the case? Is there any chance of a compromise between the SEC and Ripple? There's a lot to unpack here, and attorney John DT gave me some great insight, but for now, I'll just stick with the basics. The topic is very fascinating. Observing the presence of these lawyers in the wild, I find the bias of some of them to be laughable. Nonetheless, it was enough to see them because that lawyer had predicted a crushing loss for Ripple. They were dead incorrect, obviously. They've tripled down on their foolish plans. Quite a few of them, at least, who are predicting that the situation will soon be turned around. Oh, that's right, we've made a choice. So I'll explain that it's all nonsense, but they've already been shown to be wrong if they insist on believing that their flawed ideas will somehow be vindicated by a higher authority. In particular, their error with respect to XRP is glaringly apparent. To be more precise, which part of this whole darn thing is the most crucial? The asset itself is never at risk. A security, if you will. Assuming you mean to discuss something else entirely, listen, I've got a list to show you. I've experimented with this on my channel a few times. However, there is a valid explanation for this. But before I go any further, I should mention that I have no training in law or finance. I am not qualified to give you financial or legal guidance. And you should not make any financial decisions based on what I write or say. I'm just a fan who occasionally dabbles in crypto-related YouTube video production for the sake of entertainment. Look at the headline you've written today. An SEC official has warned that XRP is in a precarious position and is preparing an appeal, a move that could have far-reaching consequences for the future of the cryptocurrency. XRP ex-SEC official John Reed Stark has expressed concern that the present ruling in favor of Ripple is not completely solid. Moreover, he warned that the SEC plans to appeal, which might reverse the ruling. Absolutely fantastic. The judge merely used an old statute from 1946. Only that was accomplished by her. The Howey test is being examined. That's what she meant by saying that, XRP. And this man is just so dishonest on a philosophical level. He seems absolutely irrational, and I can't believe he actually believes what he's saying. Not all lawyers are corrupt, not even my fellow ex-SEC lawyers. In reality, there is a lawyer named Mark Fago, whose reasoning I don't find convincing, but who seems to truly believe it. And one way to get a feel for it is by listening to things that attorney Fagel says that I find myself agreeing with. Since I don't find a single thing John Reed Stark has said to which I've thought, yeah, that makes sense, I assume he's trying to be intellectually honest by not agreeing with anything he says. That is correct. Plus, he blocks a number of XRP holders who are, even if they are being pledged for no reason, only for posing controversial views. Make a manly fool of yourself. Here's today's second splashy announcement from Ripple and XRP. Appeal might put a damper on the celebration. Thank you, seasoned SEC member. And now, for the featured viewpoint from Mark Fail, a former attorney with the SEC. Someone on Twitter with the handle @SardonicsBull made the following comment about Judge Torres. Given that buyers and sellers on exchanges are often strangers to one another, he says, I believe she said there was no contract. Yeah. Dead on. How do you know that being tall makes you happy? To what extent can you trust an unknown seller to raise the XRP price without first establishing his or her identity? The thought that a higher court will reverse this is, therefore, utterly absurd, in my opinion. However, lawyer Fagel does not agree. So he shot back saying maybe from a contract law perspective, but not from a securities perspective. You don't know who you're purchasing shares from, so the idea that the conclusion is drastically different for an investment transaction is irrational is ridiculous. There's a significant likelihood the Second Circuit will decide to reverse the lower court. Oh, he does believe that a higher court will reverse, but I don't buy his reasoning. I'm also not an attorney, by the way. However, many lawyers agree with me that what I'm stating here makes logic. But, he repeated, you never know who you're dealing with in the stock market. So, what the heck does that even mean? Where does that fit in here? The Cornell Law School webpage is presented here for reference, however, the same data may be found here. Definitions, including those pertaining to the creation of securities, can be found in Article 78. What you see on your screen right now is a definition, or explanation, of the phrase security, and I don't need to read the whole thing. They use it directly in the text. Now, if you're paying attention, you'll see that I circled stock as one of those items. Is XRP included in that? Does it include Bitcoin, other cryptocurrencies, and digital assets? No. It doesn't make any sense for him to suggest that you can't know who you're buying from or what you're getting when investing in a security like shares. His words exactly. No, with all due respect, Attorney Fagel, your stance on the MSA is absurd. It's not what's shown on the screen, so it must be something else. A security is defined as anything on that list, anything else is merely an asset. It may be used as part of a plan that ultimately amounts to a financial agreement. Yes. However, this is in no way equivalent. Just saying. How he can claim otherwise while maintaining a straight face is beyond me. A tweet from an attorney professor remarked, I have no skin in the game and don't really care, although he does appear to be this way. Both parties, in my judgment, will file appeals. The SEC has a better than even chance of having the decision on the automated sales overturned. I just don't understand how he can think it makes any kind of sense. However, he believes that the clarity we had from X or from Judge towards the fact that XRP is not a security can be reversed even on the programmatic sales. And I'll admit that, well, technically speaking, everything is possible. But the likelihood of that happening is practically nil. I couldn't give a hoot if I didn't. I really don't give a damn about it. Unfortunately, I think Mark is accurate, and both sides will appeal unless there is a settlement, Attorney Morgan retweeted, adding. Now Attorney Fagels remarked in response, I don't see how a settlement happens. The summary judgment ruling would remain in effect. Furthermore, if that decision is adopted by other courts, it will have far-reaching effects for the SEC in crypto cases. If the SEC truly believed the ruling was correct, Attorney Morgan replied, then it would occur. Unless they are confident that their decision is correct, prosecutors and government agencies should not pursue a matter for the sake of policy or act like a private party seeking to win at all costs and exhaust the other party. Okay. So Attorney Morgan is correct, though I would add that, given that we're dealing with the SEC, I don't believe they're operating in good faith and would resort to acting in bad faith if necessary to achieve the outcome they seek. The attorney then retorted, when there is ambiguity in the law or any emerging novel issue, a party can have a good faith basis for pursuing a legal position, despite the counterarguments. The court's analysis allowed them to raise a valid objection. A user named Kev then retorted, Mark, do you agree with Attorney Deaton that nobody can appeal until the case has concluded after the trial? It's possible that won't happen until 2024. Both parties have the right to file for what is called an internal locutory appeal, but the appeals court and trial court must grant it. He is essentially suggesting that despite what you may be claiming, an appeal may be filed by either party. That doesn't imply they'll automatically succeed, though. Then he adds that there is a legal precedent for this to occur. But predicting this is challenging. If that does not occur, then the appeal can be filed after the trial has concluded. Solicitor Deaton now intervenes. Moreover, this viewpoint is among the most intriguing I've heard. In this video, I hope to tell you that Lawyer Deaton says I wasn't trying to imply anything when I said an appeal couldn't be made before a jury verdict. The only catch is that you can't go to court for an appeal. either party may petition Judge Torres for permission, and if granted, may appeal to the Second Circuit for approval. Since the SEC moved for summary judgment under Howey, I don't think Judge Torres will sign off on it. The judge used the Howey principles rigorously to each category of XRP sale that the SEC claimed violated regulations. The SEC has requested that you take action in regards to resolving violations for certain XRP sales types if you are found to be in violation. The SEC is a bunch of babies in the office, therefore they don't like it when your judge goes on tour. Then, after appealing, they come back. What do you say to it if you're a judge on tour? How seriously do you take that? Probably not, definitely not, is what I'm thinking. Not only would she not have to consent, more importantly, the court agreed that the Howey test was controlling and applied it properly, and then Attorney Dean said the court agreed with him. The court basically applied a Supreme Court criteria that has been well established for 76 years to the facts of the case. Despite objections to her rationale or policy considerations, this case is a clear application of that well-defined rule. Why would she, given the nature of her decision, grant an appeal at this stage? It's possible that the parties will present a persuasive written argument. But I just don't see it happening right now. So, you are right on target. And that's why I think you're on slippery ground with this XRP thing, because former SEC attorney John Reed Stark says there's a strong chance it'll be reversed. Our 4 pillars of protection. I have no doubt that the judge followed long-standing precedents. This 76-year-old man is a legal precedent from the Howey test of 1946. That's just not something I see occurring. Also, I would be amazed if Ripple would consent to an interlocutory appeal in order to cross-appeal an OTSL sale, Attorney Deaton wrote. If I were the attorney for Ripple's 2 executives, I would get up from my chair and pound the table in protest of an early appeal, explaining that the case has already dragged on for 3 years, not including the 30 months spent on the investigation. And it's been a cloud that this business hasn't been able to shake. It involves 2 high-level executives and no fraud. Still, they need to have their day in court as quickly as possible. In this case, we merely applied our standard operating procedure to the data provided by the SEC, and the SEC won on certain sales. Having this become the law of the land for the next 2 to 3 years is something I would strongly object to. I agree, I can't think of a good reason for Ripple to do that. Even I can see the logic in that. This was also written by Attorney Deaton. Interesting things have been stated about XRP since Thursday, when Judge Torres's judgment was made public. Many people, including very intelligent and experienced lawyers, have shown a heightened amount of confirmation bias in their analysis of the Torres ruling. Those who previously predicted a unanimous SEC win, the SEC has never lost a crypto case, XRP is clearly a security, etc., now believe the Second Circuit will reverse the Torres. They obviously made a mistake. Right. Some of those applauding the traveler's judgment, however, including some very smart and experienced lawyers, have described it as appeal-proof, and an appealing decision on this matter would take another 2 to 3 years. Keep in mind that the trial will take place before the appeal is heard. Despite an appeals judgment being 2 to 3 years away, the Torres judgment is the law of the land until then. It's undeniably one of the hottest debates going on right now. Yeah. Is that not luxurious? People who thought the SEC wouldn't have any trouble classifying XRP as a security were, obviously, mistaken. And they're being even more stubborn about their illogical beliefs. No, it's just a terrible decision that will be reversed. But where does it fall apart if we talk about the actual reasoning, the application of the Howey test, the application of real law to these cases? The acid is not the safety mechanism. Why can't they just take that at face value? So, in Attorney Deaton's opinion, who is correct? On Tuesday's broadcast, we'll be diving headfirst into this topic of crypto law. Indeed, confirmation bias exists. That's why I'm bringing in a special guest to help me give a fair assessment of the Torres judgment and whether or not it will hold up in appeal. To that end, I anticipate anticipation. Now that I've read a plethora of arguments for and against, I thought I'd offer my own take. However, I do not believe that this particular piece of the issue, the assumption that XRP itself is not secured, is going to be worsened. Please use the Howey test already. You would as well declare oranges are securities and no fool that is Jesus if it happens. I don't give advice on money. Please like and subscribe my channel. See you later, bye.